Hi, everybody. New Jersey Forensic Accountant here today. We're going to go over pro se, the greatest victory in the last 50 years. This is part 3 of the video, so if you want some more background, go take a look at part 1 and 2. This is a case that I was actually pro se in, even though I'm not an attorney, and went up against Harvard, one of the most powerful institutions in Massachusetts, if not the country. Basically forced into this situation because most lawyers were very shy about going up against Harvard in a simple, straightforward case like this. And the reason it's referred to as one of the greatest victories is because many of the courts it went through. Let's just take a quick look at those courts that the case went through. It went through the New Jersey Superior Court, United States District Court of New Jersey before 2 federal judges, which in both cases I won motions. United States Court of Appeals for the Third Circuit, United States District Court of Massachusetts, Massachusetts Judicial Conduct Proceedings, Massachusetts Petition for Review of Judicial Conduct Proceedings, United States Court of Appeals for the First Circuit, and possibly the Supreme Court. Now, when you go pro se, you're allowed to go pro se based on federal court rulings. However, the court system is not set up for pro se litigants. Generally, judges and their staff don't like pro se litigants for a variety of reasons. Some of them are, legitimate. But basically, if you go pro se, you could assume that you're going to be discriminated against, and at least there's going to be some bias against you. Now, when the cases moved up to Massachusetts, some funny things started to happen. But the first thing we did was receive, I'm going to go through some of the notices just so you can see what they look like. Notices of scheduling conference, notice of appearance. These are things that happened, and then some odd rulings. Let's just take a look at those notices. This is a notice of the case being moved up to district court. We received that in 2021, and it goes through some specifics. And again, since we're pro se, it was pretty interesting. Like, I had no lawyers at all because I just didn't want to bring anybody in, and I think it wouldn't be fair to them to bring an attorney into a complex case like this. And then here's my notice of appearance. Hey, listen, I'm pro se. I'm going up against Harvard. This is the case that the judge was assigned to this judge. And just some information you have to do if you're going pro se. And here's a press release put out by the District Court of Massachusetts talking about the judge the case was assigned to. Obviously, you're hoping for a fair and unbiased judge, but we have a judge that's a Harvard College graduate and a Harvard Law School graduate, only one in Boston with those credentials. So I don't know how he got picked. That's pretty interesting. Judge Young is lectured at Harvard Law School, an active alumni of Harvard. Judge Young has received various capacities. He was for the college. He's on the Board of Overseers, alumni. Basically, his whole life revolves around Harvard. Now, what's really interesting here is that if you look at this Board of Overseers that the judge is on, it's basically a management position at Harvard. Okay, you have to protect Harvard. You have to guide the principals. You do everything. You're basically a manager working for Harvard. So essentially what I have here as a Harvard employee as the judge of this case. And Harvard was losing this case left and right in New Jersey. The majority rulings were my favorite. A couple we lost. But this is over $800 million lawsuit, discrimination lawsuit. And they get this judge. Didn't disclose none of this. We had no idea we were dealing with this judge because I would never have okayed it. Okay, this case should have went back to New Jersey. But anyway, let's go back and see what happened. So the case was moved up in 21, as we looked at. And some interesting things happened. First of all, if you're in litigation pro se, you need to get on the electronic filing system for the federal court system, because if you don't, your case is almost going to be impossible to win. And we tried to get on it. We couldn't get on it. The judge just ignored our pleadings. We submitted like a 300 or 400 page pleading, and we weren't on the E.F.C., so we had to overnight it. Complete disaster. Put us at a tremendous disadvantage. Finally, the judge that day let us on the ECF. Okay, he kind of got the idea that we were not playing. And obviously, this hurt us a lot in the case. Oh, you know what? Let me just show you this one thing. This here is the building where the district court is and the first court circuit of appeals. So they're all buddy-buddy. They're all basically one court. Beautiful building. Courtrooms are awesome, right over the water in Boston. If you ever get a chance to go up there, take a look at this. But anyway, so it moved up to Massachusetts. And, first we had the notice of scheduling. I showed you that. Then we had, the case was, ECF notice filed, was assigned to a federal district court judge. We talked about his credentials, obviously a Harvard employee. I filed notice of appearance. Harvard filed their second notice to dismiss. Now, they filed one in New Jersey. They lost. Judge said, we deserve discovery, but they filed the second one. Now, they filed what's called a federal 12B6 ruling, a motion, which basically is claiming I didn't state a claim in that relief could be granted on, which is total BS. These motions never win, okay? They never win, especially with our complaint, which was well written. But just in case, I amended the complaint. Instead of a 15-page complaint, I made it a 250-page complaint. So the judge would never, any fair judge would never be able to dismiss it. But they made that complaint. Now, I sent in, I filed a reply brief to the plaintiff's opposition to Harvard's second motion, explained that, this is a legitimate case. We did their discovery. No one dismisses a motion based on a 12B6 ruling. Then Harvard, they had in their documentation some false information that they submitted with this motion. And they tried to turn the motion into a summary judgment based on new documents that were fraudulent. And they were successful, I have to tell you. If you take a look, it contained new discoveries and fraudulent documentations. Now, I'm going to give you this, just show you so you understand where the fraudulent information was and how it was handled. We're going to review this in depth in the next, in a video where we go in and show you how these documents were false. The judge knew they were false, but he still used them. And let's just take a look. Okay, this is a copy of their motion to dismiss that Harvard submitted. You can see all the information here. Now, in this motion, which the court knew, I explained it to them in detail, there's all kinds of false documents that we never seen. There's we never got discovery. Basically, it's lies. And you can't submit that in this motion. You could lie in court if you're a lawyer, or, they obviously don't have to tell the truth. But if you can't submit documentation that has never been seen by the plaintiff at this point. Okay, and they're saying we can submit fraudulent documents that are unauthentic and that the plaintiff never seen based on this case. Now, case law is really important for attorneys. And what they're doing is they're taking this case, Angelos versus Topeka Pharma. Okay, and they're saying a complaint factual allegations are expressly linked to and immediately dependent upon a document. This is a key, ... Something was taken out here. The document effectively merges into the pleadings, and the trial court can review it and decide a motion to dismiss under Rule 12b-6. And they cite this case. This is the whole crux of all the documentation in the district court. Okay, they're saying, Your Honor, we could submit fake documents based on this case law. Okay, we could, even though the plaintiff didn't have discovery, even though the plaintiff never saw these, you can make a ruling on this. Okay, now let's go to the document. Let's go to the actual case law and see if what they're saying is true here. Okay, this here is the case. Okay, and if you look at what actually the court is saying here, they're saying here, this is the quote that they took. A complaint's factual allegations are expressly linked to, admittedly dependent upon, a document. And this is where the ... the authenticity of which is not challenged. Okay, that document effectively merges into pleadings, and the trial court can review it in deciding a motion to dismiss under 12b. So they're saying this, but they took out the authenticity of which is not challenged. Now, if I challenge it, which I did multiple times, the judge can't make the ruling to dismiss the case on it. It's illegal. Okay, unless he's an employee of Harvard, which he was. So this here means that their whole complaint, which is full of stuff that I never seen, it was false, it was made up stuff. Okay, and the judge knew it, and this is why they can't do it. This here is very clear that if I object and the authenticity of which is challenged, I just have to challenge it. The judge can't rely on it. But he did. So listen, I'm going to stop here because we're getting close to 10 minutes. If you guys like the video, smash the like button. Leave me any comments below. We're going to follow up with video number 4 on this matter. We're going to go into this in detail, and the big one is going to be the hearing, which is absolutely hilarious. So I'll see you later. Thanks.